afternoon and welcome to this webinar um, on uh, on some aspects of appearing in court. Uh, you probably received a note from Betty, my coordinator, that we may run beyond 4 o'clock. This is quite a comprehensive course, and it's usually done over 2 days. So I'm going to try and squeeze this into 3 hours. So let's see how we get along. I'll try and give you some time to ask questions, which I'll then deal with. Appearing in court. By the way, I will give you a break, a comfort break at around 2:30. And then we'll carry on. Just to introduce you to the subject, you probably know that it's only something like 6% or even less of LLBs that actually become trial lawyers. Most LLBs don't venture into court. They would enter the corporate world. They will do chamber work, consulting, contract work, tax. There's a whole area of law which provides opportunities for young graduates. Being a trial lawyer is one discipline. It is not the most popular one. I know it's romanticized in movies and TV and so on, but the reality is that someone is saying I'm on mute, Betty.
No, I hear you loud and clear, sir. If we could just get indication from the rest of the group.
Yeah. Okay. No one else is complaining. Okay. So what I want to point out is that the reason why being a trial lawyer is not so popular is because it is a skill that involves performance in a public space. So you are performing in public, on your feet, with a rather critical audience in the form of a judge, your opponent, and there's also a gallery that's observing you. So many people are not comfortable performing in public. It also requires a number of skills within the courtroom so that you can be very effective in what you do. Now, to start with, you must understand that in our country, the courts where we resolve disputes on a daily basis use the adversarial system and not the inquisitorial system. What this means is that the judge does not have much scope for getting involved in the matter. Our judges cannot investigate the facts as does an inquisitorial judge. An adversarial judge can only make a finding of fact based on the evidence presented by the parties. And there's very little scope to go outside of that. What this means is when the parties, if they present the judge with good quality evidence, the judge is able to make a good decision. Judges often are criticized for not listening, being incompetent, getting it wrong, and so on. Well, much of the blame must rest with the practitioners. The practitioners are there to assist the judge and, more importantly, to persuade the judge to find in your favor. Now, that's what this course is about. to show you the various techniques that are involved in presenting your facts so that the judge is persuaded to accept your version of what happened, and make a finding of fact, and then draw inferences from those facts that favor your case. Now, I'm going to start off with a quotation from an English judge, Judge Rolfe Hamerton. This is what he said. At the outset, it must be made clear that no lawyer should venture into a courtroom if he or she has not thoroughly mastered the facts of the case. This is key to successfully presenting your case to a judge. Get the facts right and the law will look after itself. I couldn't put that better myself. When you're a trial lawyer, two things matter. Firstly, you must have the ability to get on your feet in court and present effectively. If you're a shy, shrinking flower, that's not going to work. You need to have a robust approach. You have to combine this with some elegance and some drama. But I don't care how good you are on your feet. You can be as elegant as you like. If you don't know the facts of your case, you are not going to succeed, because ultimately the judge will have to make a finding of fact before the judge applies the law. The judge, remember, is an adversarial judge. The judge is not a seeker of the truth. What the judge is looking for is to be persuaded by the one version that the judge finds is likely to have happened. Now, right from the beginning, let's remember the test, the onus of proof in a civil trial. It is on a balance of probabilities. Now, you learned that in civil procedure at university. But of course, none of those lecturers were able to explain what that means. Well, what it really means is that when a judge hears a version from a witness, the judge is not required to determine whether it is true. Because a judge won't know if it's true. You won't know if your client is telling the truth or if your witness is telling the truth. You are not there. But one thing lawyers can do, and this is what judges do, they will listen to the evidence. If the witness is not completely discredited, the judge will consider the version presented by the witness. And in the light of the circumstances of the case and the undisputed facts, the judge will ask a single question. Is that likely to have happened? Is that version plausible? If the judge finds it implausible, if it's not probable, the judge will reject it. But if the judge finds that the version is probable, then the judge will say, for purposes of this hearing, I am persuaded that the witness told the truth. Why? Not because the judge is convinced that what the witness said is true, but because the judge was persuaded that the version was likely to have happened. And that's very important to remember. So I'll say a bit more about that as we go along. Now, there are three important things for you to remember. Your story must be about people and events. Contrary to what you might have heard, judges are people who are concerned about doing the right thing. That's true. Your job is to be of assistance to the judge. Tell the judge what happened. Present the incidents, the people, the facts, the transactions. Remember, when you make factual and legal submissions in support of your case, your submissions must be supported by the facts. Equally, you cannot rely on any law if the law is not supported by the facts of your case. That's the first thing. Next, the judge is not inquisitorial. the judge can make findings of fact only on the evidence presented. You are likely to get a poor result if you do not provide the judge with the available facts. A trial is much more than putting your client's version of the facts on record. You have to organize the facts, present them as part of an organized story, and it must be presented in a manner that is persuasive. Trials are definitely not about reading the pleadings, attending a pretrial conference, and going to court and calling your first witness. It's a lot more than that. And that's what I want to demonstrate to you. So here is a checklist of what you should concentrate on before you go to court. I would prefer it if you could tick all of these before you go to court. What are the triable issues? You'll be surprised how often the parties come to court and the lawyers are not clear on what the issue is. Now, what's happened recently, well, most of you have read pleadings in the High Court. The pleadings are not particularly helpful. You can test it. Go and draw 10 files out of the High Court, read the particulars of claim and the plea, and ask yourself, what's this case about? There's a vague reference to a cause of action, and the pleadings are based on precedent. The peculiar facts of the case are rarely pleaded. So the judges don't really know what the issue is. And you cannot possibly start a trial if the lawyers and the judge does not know what the issue is. What's the question to be answered? What is the dispute that needs to be resolved? Judge needs to know that. Now, what we've done in this province, it's not done in the other provinces, not yet. I think the Western Cape does it. During case management, the judges, the case managing judge, will insist that the parties must get together, agree on what the issue is, and write it down. Now, this is usually, we used to have a form. I don't know if that form is still there. Both in Johannesburg and Pretoria, this is the case management form. There's a paragraph in there which requires practitioners to state the triable issues without reference to the pleadings. So this went some way towards resolving the problem, where the parties are compelled to agree on the issues before coming to court. And of course, when that is minuted either in the form, or usually it's minuted in a case, the minutes of a case conference or pre-trial conference. Now, before the judge comes into court, the judge will read the pleadings and the minutes. That will tell the judge what the matter is about and what the issue is. So you shouldn't have too much difficulty in the opening statement. So it's very important to establish the triable issues. You know, I recommend that as a general principle, you should stop being adversarial lawyers. This adversarial litigation that we are so used to doesn't really work. You're familiar with the recent introduction of Rule 41A, which compels parties to talk, to negotiate, to mediate. We want to avoid, we want to encourage lawyers to stop being adversarial. South African lawyers are terribly adversarial. I mean, I learned to be an adversarial litigator from the days of my being an article clerk. And from then on, I spent 40 years in courts. We were adversarial. We never cooperated with each other. We never made admissions. We never had case conferences. None of those things. I'm suggesting to you, be more cooperative with your opponent. Talk to your opponent. You are colleagues. And one of the purposes of case management is to try and get parties to resolve as many issues as possible outside court, so we do not waste valuable court time. Then the next thing on the list is who bears the onus. Now, the general rule is that the plaintiff bears the onus, but the cause of action and the manner in which it is pleaded by the defendant might attract the duty to begin. The defendant might attract the duty to begin. Now, this is also an issue that you must resolve before you come to court. Judges hate it when you come to court and in opening statement you tell the judge, well, my lord, we have to decide the question of onus. We were unable to agree. That means the judge now has to hear an opposed application before they start the trial. That's not on anymore. The judge will be seriously irritated. So you can deal with onus in the pretrial conference, and let's assume you can't agree with your opponent for whatever reason. You can then take the matter to judicial case management, get a judge who will sit in case management and will assist the parties to decide who bears the onus or who bears the duty to begin. Then the third one, what is my case concept or theory of my case? What this means in plain language is what happened according to my version of the disputed facts. Now, every lawyer needs to know that before you go to court. What happened according to my client's version of the facts? Because that is what will assist you to navigate your way from pleadings through to final argument. You must know this. I always tell lawyers, you know, when a client sits down to give you instructions, one of the best questions you can ask is, what happened? Tell me what happened. Because it's their case, it's their problem. Listen to them first. Work out what the theory of your case is or your case concept. The next point is, have you done a proof analysis? Now, this is poor preparation if you didn't do it. What does this involve? Okay, so pleadings have closed, you've seen the discovery, you've read the expert notices, and so on. Now you've got to go to your cause of action as plaintiff. Work out on the remaining issue between the parties. What are the material facts that require proof? In other words, what are my facta probanda? The material facts that I have to prove in order to get the relief that I want. Now, cause of action is defined as the facts which the law recognizes as giving you a claim. That's the basic definition. If you look at the definition, it's about the facts. The law is the easy part. It's the facts that are difficult. So your cause of action will be made up of material facts which you must prove, so that if you satisfy the court, the law says that you will get the following relief. It could be payment of a contract, it could be enforcement, it could be delictual damages, whatever. Your job is to take each of those material facts and ask yourself, how will I provide proof of those facts? Who will be my witnesses? What documentation will I need? Will I need an expert? What visual evidence will I need? That is an analysis that you have to do. You need a witness analysis. Having done a proof analysis, you would have selected a number of witnesses, you have to take each witness and ask the question, what is this witness's version? What material fact will emerge from this witness? This witness will present proof of what fact? That's the question that you have to ask. Now, a very good technique is to write all this down. Don't think, oh, okay, I've read the witness's statement, now I know what to do. Write it down. Witness name, the material facts. Because when you go to court, you cannot call a witness who is not relevant to the dispute. The evidence, the first test, must be relevant to the issue. Otherwise, it doesn't help the judge. You wasted everyone's time. All right, the next thing is, where's my chronology document? Now, a practice has developed in our courts, mostly over the last 10 years. Going back, we didn't use chronology documents in court. And judges used to be misdirected. Advocates and attorneys got misdirected because they did not take their facts and present it in a chronological sequence. Those of you familiar with the rules and directives will know that in the SCA Constitutional Court, in the opposed courts, motion courts in this province, you are expected to file a chronology document or chronology table with your heads of argument. So my recommendation to you as trial lawyers, always prepare a chronology document. What this is a simple document, 3 columns. First column, very narrow column for numbering. The middle column is to describe the material facts, the incidents that you will rely on, and put the date or time in the third column on the right. This gives you, firstly, and then the judge, a picture of what this case is about and how the evidence will be presented. It gives the judge the chronology. Chronologies assist judges to work out if the version is probable. If the chronology doesn't make sense, the judge is likely to find that the version is improbable, or aspects of that version will be improbable. I'll say a little more about chronology documents later. Where's my ranking of my witnesses? Now, here's something that you must take into account. When a judge comes into court, the judge will hear an opening statement, but most judges are very keen to hear the first witness, because that's when the case starts taking shape. The judge wants to hear the first witness. The rule is, for a lawyer, always start with your strongest witness. This is not a criminal court. In criminal courts, if you're for defense, you have to start with the accused. If you are for the state, the same rule applies. Start with your best witness. If you start with the worst, with your second best witness, or even your worst witness, the judge is not impressed. The judge thinks that, well, perhaps you don't have a case. And then when you call your next witness, who is a better witness, you are on your back foot. What you're doing is you're trying to rescue your case now. Never start with a poor witness. Always start with the best witness you have. Now, the problem arises where in the morning, your best witness is not there. Your number 3 witness is there from 8 o'clock, Murphy's Law. Don't be compelled by the judge or by your opponent to start with the available witness. That's not the test. You start with your best witness, not with an available witness. So the onus is on the practitioners to see to it that they rank their witnesses and start with the best witness. It's also a good strategy because if your best witness goes really well, it is usually not necessary to call supporting witnesses. The second witness or a third witness, corroboration may not be necessary. And it's far more persuasive than giving the judge a whole lot of witnesses, and they vary in quality. The next question, am I ready to provide the court with proof of my material facts? I've dealt with this, the facta probanda. Go to your pleadings, look at the pre-trial minutes, work out what the issue is. In respect of those issues, what are the material facts I will have to prove in order to succeed in discharging the onus? That's the question. And lastly, where's my draft heads of argument? Now, just as a piece of advice, there are no rules nor directives that compel you to prepare heads in a trial, in a civil trial. But my advice to you, if you want to be successful litigators, always draft heads of argument. And the most important reason for doing so is that there is absolutely nothing better than drafting heads to prepare yourself for the trial. Now, one of the things you should do is when you're preparing the evidence, you're reading a witness's statement, you consulted with a witness, you should, as soon as possible, open a file on your computer and write down why this witness, what are the important facts, and why is this witness necessary, and for as proof of what fact. Write that down. You do that with all the witnesses you have. Same with your experts. By the way, experts are no longer a big problem because they are case managed. And I'll deal with that later. Now, why I say you should write as you go is because when you write, you're applying your mind. When you read a statement, you may not have read it actively. You may have read it passively. You are not applying your mind to it. By the way, everything you do as a lawyer requires you to apply your mind. Reason is very important. The way you apply logic and reason in coming to your factual and legal submissions must be demonstrated to the judge. Repeating evidence to a judge is of no use at all. Likewise, when you're researching the law, by the way, for a trial lawyer, the law is the most recent decision of the highest court. That's all you need. You can forget about the textbooks and articles and all the rest of it. That's what you need, because that's the law that is binding on your trial judge. That's what you give the trial judge. Now, when you read a case, for heaven's sake, don't just read it and put it aside or flag it for later reference. You're wasting time because you'll have to read it again. Read it, understand the point you want to use, write it down in your own words, and make a note of the reference. So when you've done all your preparation, the evidence and the law, you would have written various short paragraphs, and you saved it in your computer. What you now do is you copy and paste from there in the order that you want, and right there, bingo, you've got your draft heads of argument. The idea is for you to have heads before you walk into court, is because your heads will guide you through the whole trial. And then at the end of the trial, it is always useful to hand up a set of heads to the judge. These days, judges will ask you to provide heads of argument. if you did your work properly, you'll already have a draft. It'll take you maybe an hour to tighten it up, and you can hand it in. Good lawyer. So then let's go and look at what judges are doing. It's good for a lawyer, trial lawyer, to have an understanding of how the judge's mind is working. Now, what is the judge looking for? The story is told by witnesses who have personal knowledge of what actually happened. Now, a persuasive witness is a witness who testifies from personal knowledge. In other words, this is the eyewitness. This is the judge's favorite. They like eyewitnesses. So the version must account for the undisputed facts, which facts must support the version tendered by the witness. Now, just let me pause here for a moment. This is a very important point, which many practitioners ignore. When you are dealing with a trial, you'll have broadly two sets of facts: the undisputed facts and the disputed facts. The disputed facts will form the issue of fact that needs to be resolved by a judge in the trial. But there's a whole lot of undisputed facts. Now, in any dispute that you take to court, there will be a set of undisputed facts between the parties. And after pleadings close and discovery is done, the parties will get together in a pretrial conference and they will make admissions of fact, which eliminates a number of issues, and your list of undisputed facts will grow. Good lawyer will always make a note of all the undisputed facts. Why? Because judges use the undisputed facts to test the probabilities of the witness's version on the disputed facts. Remember, I told you the judge doesn't have to find that the witness is telling the truth. All the judge has to do is ask, is that version likely to have happened? One of the indicators are the undisputed facts. If the undisputed facts do not support the witness's version, the judge is likely to say, the version is improbable, I don't accept it. Okay, so remember that. Good advice is for you to write down the undisputed facts. Write it down in a file. Why this is important is that you can use them to very good effect in cross-examination. You know, when you are cross-examining your opponent's witness and you put undisputed facts to that witness in the form of leading questions, the witness stands there and just agrees with you and goes, yes, yes, yes. And it looks very impressive. And it's very useful for that reason as well. The judge wants the version to be presented by credible witnesses. Now, we will come to credibility. Judges evaluate witnesses before they can make findings of fact. I'll show you how you do that in a short while. The version must be supported by relevant detail. You know, when a judge is left wondering, what happened? I'm not sure how this happened. How did this incident take place? There's no detail. Now, when you lead a witness who is vague, it doesn't help your case, because it doesn't help the judge. But when you lead a witness who is vague, your opponent will have a field day in cross-examination and will easily discredit that witness. The version must be probable in relation to the circumstances of the case. Now, just get one thing straight. If your client or your witness gives you a version that is not likely to have happened, it's improbable. Don't call that witness, a judge will reject it. If you have no version that amounts to a probable or sustainable version, then for God's sake, use Rule 41A and go and talk settlement. If you go to court with it, you will pay the price. By the way, there's a very good article written by SCA judge. It's called In Pursuit of the Hopeless Case. There's a whole lot of debate going on amongst lawyers around going to court with a case that has absolutely no merits. You know, in the past, we got away with it. You got no merits, you go to court because you can. You go to court, and if the judge says to you, but Mr. Hussein, this is nonsense. Why did you come to court with this? We had the same answer. We used to say, well, my lord, those are my instructions. And we got away with it. Well, you won't get away with it now. The new reasoning is that you are an officer of the court. If your client has a rubbish case, you will know it's a rubbish case. You have no business going and using scarce resources and wasting court time with it. You'll get punished. Judges are now beginning to punish lawyers who go to court with a hopeless case just because they can, or just because they have instructions, or just because they have a healthy deposit in the trust account. So don't go to court with a case with facts that flow out of a version that is not likely to have happened. The version must be presented in a sequence, chronological sequence. That's how judges want it. Go and read judgments. You will see that judges always will deal with the facts in a chronological sequence. That's how they want it. That's how you present it. The version must be, the version presented must consist of admissible evidence. In other words, the first test is relevance. The witness must first be relevant. The evidence must be relevant to the dispute, the issue. But the second test is that it's not enough for the witness to be relevant. The evidence must be in a form that is admissible. So the witness may be relevant, but the evidence is hearsay. The evidence is still subject to the rules of evidence. It's part of our procedural law. So you always test a witness on the basis that, can I lead this evidence? Will it be admissible? That's what the judge will ask. The version of material facts must contain all the elements of a legally recognizable cause of action or defense. Now, I told you that the plaintiff must have a cause of action. If not, it's excipiable. You all know that. Equally, the defendant must have a defense that is recognizable in law, or in fact and in law. These pleadings where the defendant merely pleads a bare denial, well, you will not get away with it anymore. You will be found out in case management in the first place. Again, I say, if you have no case, don't go to court. With case management, by the time you get certified trial ready, between the judge and the case conferences held by the lawyers, including your pre-trial conference, you would have worked out what the cause of action is and which material fact or facts in that cause of action requires proof at a trial. You would have done that. The judge will expect the version to come across clearly, logically, and must be probable. Any version that appears to be improbable or contains elements of fact which the judge finds implausible is not likely to be persuasive, and your client will not discharge the onus. Always keep the evidence relevant. The one thing judges hate is when you get irrelevant in court. You'll see it all the time. A witness is testifying for 20 minutes, and the judge looks up and says, "Is there any point in this? Or why did you call this witness?" When a judge does that, simply means that he can't work out the relevance. Always keep it relevant and keep it short. This has come under scrutiny as well. In Gauteng, and only in Gauteng, we do not use a fixed role. We use a continuing role. So trials are set down, although you make an estimate for the judge, for the presiding judge, well, we will let you go beyond that if you can finish it within a day or so. In the other divisions, you'll have to estimate how many days you need, and your case will be set down only for those days. The problem is if you don't finish, you'll end up with a part-heard case. By the way, good advice. Avoid part-heard cases like the plague. They waste time, they waste costs, and it's not good for the merits of your case either. The judge will seek out the agreed facts and undisputed facts as an anchor or base from which to build a picture of what the judge can safely find is more likely to have happened when forced to choose between conflicting versions. There's the point. The judge wasn't there. The judge wants to know what happened. What's important to the judge is to use the undisputed facts and circumstances, which will provide the judge with an anchor or a framework within which to test the disputed version and ask, is this likely to have happened? The answer is no, you're going to lose. When your evidence is weak or your version is implausible, there are no documents to support it. You're not helping the judge to come to any reasoned conclusion in your favor. Now, remember, one of the things about adversarial courts and trials is that the judge has to give written reasons for the findings of fact and law that he makes. So the judge needs to come to reasoned conclusions. Your job is to provide the judge with those reasons. The better quality of your evidence, the better the judgment and reasons for the judgment. Okay, this is what Lord Bingham said, a law lord in England. I think that in practice, judges do attach enormous importance to the sheer likelihood or unlikelihood of an event having happened as a witness testifies in deciding whether to accept his account or not. The likelihood, the probabilities, plausibility. This is very true of judges in our system. Okay, here is another checklist. These checklists are very useful. Before you go to court, let's see if you can tick this off. We've been through most of it already. What is your case concept? Do you know the tribal issue? What evidence to lead from which witness? What you want from each witness? You know, calling a witness is not about calling the witness to the witness box and then say to the witness, tell the court what happened. You need to control it. You need to know what's going to come out. If not, well, you're skating on thin ice because the witness will say something that will damage your case and you didn't see it coming. You need to know what to ask of your opponent's witnesses. What do you ask in cross-examination? Cross-examination also means you must know what not to ask. Is your witness relevant to the issues? Is the witness admissible? Is the version probable? Does the witness testify from personal knowledge? Did your witness have enough opportunity to observe and have a reliable recollection? It's what we call the reliability of the evidence. You'll have to test this in consultation. The witness says, this is what I saw. Good lawyer will say, okay, let's investigate that. Where were you standing? What was the lighting like? Why were you observing this incident? How can you recall what happened? Okay. And the last point here is very important. Can you support your witness with contemporary documentation? Judges like contemporary documents. Now you know why. When we enter into contracts, we'd rather enter into written agreements, not oral agreements. When a transaction happens and there is a contemporaneous document, that gives the judge external proof of what happened during the negotiations and the transaction. They are very important. You know that we have to discover all such documentation, but where you have documents that support your client's version, you must use it. Do you have supporting evidence for your client if necessary? Corroboration, for example. You'll have to check if your witness could possibly be mistaken. Have you checked for bias? Now, this can be very, very harmful. Everybody has their biases. The witnesses you call to court will have a bias. Your client will have a bias. But you really shouldn't call a witness who has an interest in the outcome of the case. They tend to get discredited very quickly. If there's some motive to testify, which can possibly discredit your witness, that's part of the bias, but you need to check this as a lawyer. Because if you don't, it will come out in cross-examination and then it's too late. Ask the question, is the witness's version supported by the undisputed facts? You will thereby establish if your witness's version is likely to have happened. Is the version contradicted by the undisputed facts? If so, you're in trouble. There's the preparation checklist. I'll go through this quickly because I've dealt with it already. Do you have a proof analysis? Where is the witness ranked in order of importance? Did you prepare a chronology document? Did you hand a chronology document to the witness and explain how you will lead? I will give you more details about this later. Does your witness have access to a written statement of their testimony? Did your witness have time to read it? Were you able to select documents you will introduce through the witness? Did you flag it in the bundle? Did you note it on case lines? And this first point, has the witness been through witness briefing? Now, please do this. South African lawyers don't do this. It's because we don't use jury trials. Witnesses, lay witnesses, somebody who observed something and you called them as a witness. These are ordinary people. They're not used to going to court. They see courts as troublesome places. It is not user-friendly. They are nervous, very nervous. What is witness briefing? It's when you call the witness, take them into court, show them around, give them a tour of the whole place, explain the procedure from the point when the orderly calls their name, where to go and stand, make them stand in the witness box, feel what it's like explain the equipment, explain all the role players and what do they do. Let them walk around the courtroom. That's very important, because if you don't do that, your witness's demeanor could suffer, not because they're dishonest or they're liars, but because they're just nervous. Now, judges make a note of demeanor, and they will then make findings based on demeanor. There's no point in you destroying your own witness's demeanor because you didn't do a witness briefing. Years ago, I mentioned this to the NPA and to the criminal justice system, that you must have witness briefing. Can you imagine somebody who is a victim of a crime now has to come into court, stand in a witness box, there's a gallery of people glaring, and there's the perpetrators sitting right in front of them. It is a daunting task. What they did in the Justice Department, they created an official called Court Preparation Official, and they do witness briefing in criminal cases. This is not a service that's available to the civil courts. You better do it. You must have a thorough knowledge of all the available facts, and you must know where each witness fits into your case concept. You have prepared a document with the main facts of the witnesses, arranged in a sequence, which you will use as a quick reference on your feet. You are satisfied that the evidence you will lead will not fall foul of the rules of evidence. It must be relevant, it must be admissible, and the version must be probable. So why do you lead a witness? The witness will be able to place the undisputed facts on record. This is important for the judge, because judges want to know what the undisputed facts are. Just to demonstrate this to you, those of you who are familiar with the opposed motion courts, you really shouldn't walk into an opposed motion court if you are not familiar with the Plascon test. The Plascon test is a test judges use to determine disputes of fact on affidavits, where they don't have the benefit of leading and cross-examination and so on. Those of you who are not familiar with this test, please go and read that judgment. Also, better still, when you go to the Plascon versus Van Riebeck's paints, in the judgment, there's a reference to two judgments of the Western Cape that precedes it. They're both Stellenbosch Farmers Winery cases. Read those cases, they explain to you what the Plascon test is about. But the point I want to make is that the Plascon test, you will see, is based on the undisputed facts between the parties. And that's what the judges use to resolve disputes. You want to present evidence that your client's version is probable and can be accepted as true. The judge must find the evidence to be clear, interesting, relevant, and probable. You want to establish your witness as both credible and reliable. You want to present facts which will enable you to present argument that your client has just discharged the onus. Now, you see, here's another good reason why you should be drafting heads. All the evidence that you lead in court is directed towards what you will say in final argument. The final argument is crucial. That's the moment of persuasion. You need a good set of heads. Okay. You want to enhance the likelihood of your client's version of the disputed facts. That's the balance of probabilities. The judge will expect your witness to lay the foundation for the admission of exhibits. You will have exhibits. Those exhibits have to be entered into the record. you do that through a witness, or it can be done through admissions. The point I want to make here is that visual evidence is highly persuasive. What is visual evidence? It's exhibits, photographs, maps, videos, satellite imagery. These are things which CCTV footage. This is evidence which the judge can see, and it is highly persuasive. Never miss an opportunity to use visual evidence. And now with the digital world, the opportunities for visual evidence and exhibits is almost limitless. You can use imagery out of social media networks. Let's take a motor vehicle collision. You need to prove that the other driver was speeding and applied emergency brakes. Well, you may not have witnesses, but you can get to the car's ECU, which records everything. What revs the car was doing, what gear it was in, whether there was emergency braking, it's all recorded there. You can extract that information. So you must be alive to these things. Some incident took place in a shopping mall. There's bound to be CCTV cameras. Go and get it. Very useful to use models in court. For example, explaining human anatomy. If you've got a model of a body in court, and you can show the judge during evidence, your expert will take the judge through this model. It is highly persuasive. Finally, I'm repeating that judges are people. They get bored. Judges can get bored. Take it that your evidence in chief can descend into boredom. And mostly you'll be the culprit. When you lead your evidence in chief, remember this is your first witness, it's your best witness, but you're leading the witness in a boring, sleep-inducing voice. The judge can hardly hear you. The witness is mostly confused. The judge will stop listening. By the way, judges do stop listening, okay? Just know that. It is up to you to ensure that the judge remains interested in your client's story. And I will deal with those techniques as we go along. Now, before we go any further, here's the golden rule. I've mentioned it many times. Your witness must be relevant, must be admissible. Now, if you look at those two, that's the golden rule of evidence that you learned at university. All relevant evidence is admissible unless excluded by a rule. That's the golden rule of evidence. Okay. What they didn't tell you at university, that's because the lecturers have never run a trial, your evidence must pass a third test. It's not enough to be relevant and admissible. It must be probable. The version must be likely to have happened. You have to satisfy all three requirements before you call that witness. If that witness fails any one of these three tests, that witness is out. Don't call the witness, okay? Now, I want to take you to the technique of dealing with questions. Leading a witness in chief and cross-examination requires you to ask questions. There's a different technique involved in leading and in cross-examination. We'll come to that. What to ask and how to frame the question is not so obvious and requires careful consideration. Being able to ask the right questions is central to your performance. It determines how you bring out the relevant evidence and how comfortably your witness performs. When I say how comfortably your witness performs, firstly, your witness must understand your question effortlessly. That will enhance the witness's comfort. If the witness is struggling to hear you or doesn't understand your question because you are being bombastic, that's a bad lawyer. Your witness is not comfortable. Use the right questions the correct way, and you will have a persuasive witness. Now, I was actually reading the autobiography of Albert Einstein, and there it's recorded that Einstein was asked to give a definition of a good question. And his answer is absolutely brilliant. He says, a good question is one that is understood and it has an answer. When you are asking witnesses questions in court, the witness must understand your question and there must be an answer. And for good lawyers, there must be a third principle. You must know the answer. Whether you're leading or cross-examining, you must know the answer. So this is brilliant. Those of you who are familiar with leading and cross-examining will understand this. A good question is one that is understood and it has an answer. Okay. Now you're on your feet. Here's some practical suggestions. When you ask a witness a question, be it in cross-examination or in chief, the witness must effortlessly understand it. The witness must know what you want. You achieve this firstly by using plain language, clear language. For God's sake, do not use big words and no over-the-top drama. Okay? The witness must hear you and understand you. Oh, by the way, this is quite interesting. I've been using and playing around with ChatGPT, and I worked out something as I used it, and that is, the more precise the question you ask it, the better the answer. If you ask a question that is ambiguous or not so clear, you get an answer that's irrelevant. Okay. There's an incident that took place this week in a trial in the United States where the lawyer, the attorney, admitted to using ChatGPT to find case law which will support his case in argument. Well, he got some references, and it turned out the references were all wrong, and in fact, some of them didn't even exist. The problem was the attorney didn't put the right question into chat. Now, this chat is the artificial intelligence prides itself as being able to hold a conversation with a human being. But all human beings, when you hold a conversation, they must be able to understand you in the first place. A common occurrence in court is when your witness asks you to repeat the question. You've seen it. Or simply tells you, I don't understand the question. That's the fault of the lawyer. Look, sometimes the witness is being evasive and they'll say, oh, could you repeat that question? Well, it's a win-win situation. If you're cross-examining and the witness keeps saying, well, can you repeat that question? You can argue that the witness was being evasive. But if it's your own witness in chief says to you, I don't understand that question, well, that's unacceptable. That shouldn't happen. Use the technique of one question, one fact. One question, one fact. Don't ask a question that has three answers. Multifaceted questions, they don't work. and they can be confusing. When you get the facts that you want, you get the answer that you want, just move on to the next question. Avoid repeating questions to elicit the same evidence. Some practitioners do this in order to emphasize the point. It's a waste of time. Judges hate it. Your question, as Einstein says, must have an answer. How do you know? Because you know the answer. If you don't know the answer, don't ask. A good lawyer will think of the answer first, then ask simple and clear questions to bring out that answer. With cross-examination, you think of the answer and you put the answer in the mouth of the witness. Very different techniques. You've got a witness, you've done a witness analysis. You know what you require from this witness. Now concentrate leading your witness to bring out those facts. Why do you need those facts? For purposes of your final argument. How do you know this? Because you did a witness analysis, you also did draft heads. That's what tells you. When you cross-examine, the same thing applies. Cross-examination is there for bringing out facts that will assist you in argument. Cross-examination is not there to break the witness, okay? That happens only on TV. Bring out the facts that you need and then move on. Now, let's deal with this thing that causes trouble with lawyers, the leading question. We know that the rules tell you that you are not supposed to ask leading questions. Why? Because asking leading questions that is of no assistance to the judge. I want to tell you a story quickly that actually explains the whole thing. When I was a young counsel at the Joburg Bar, we all heard that there was this huge case that was being heard. It was a case involving, it was an aviation case. It was an aircraft that had crashed. And some of the bar's best silks were appearing. And as young juniors, we were told, go and sit and listen. You know, these are the really top guns that are there. So off I went with some of my colleagues, and we sat there and we were listening. One of those very eminent silks was leading his witness in chief and was asking one leading question after another. The judge didn't say anything, just sat there. But we were worried now that the opponent, who was a QC, didn't say much. You just sat there as well. So one leading question after another. And then the QC rose to his feet very slowly. And then he said, my lord, may I just say how well my learned friend is giving evidence? And he sat down. That was it. The judge broke into a big smile, looked at the counsel leading the witness, and that ended it right there. Because that's what happens. If you ask leading questions, you're actually giving the evidence. And that's not credible. That damages your own witness. So a leading witness is one that's, a leading question is one that suggests an answer. You know that. The judge wants to hear testimony from the witness, not from you. The rule is when dealing with a disputed fact or the disputed version, you are not to ask leading questions. If you do, you will undermine your own witness's credibility and you look like an ass. Seriously. Judges know when you cross the line. Yeah, these days, judges will give you some leeway, but I'll show you where the line is. That you suggested an answer with the result that you diminish the weight or value of the evidence. That's the problem. When you give the evidence, you've diminished the weight and value of it, because the judge doesn't want to hear you giving evidence. Remember, there's nothing wrong with bringing out facts, using leading questions to bring out facts that are not in dispute. But there's a technique. You know, bringing out facts using leading questions can save a lot of court time because it's quick. The witness just simply answers yes, 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 and you've got everything on record. But don't take it for granted. First, go and tell your opponent that you will be leading the witness on these undisputed facts. Does he have any objection? Your opponent will say, no, go ahead. When you're on your feet and you start leading your witness in chief, tell the judge, my lord, I'm going to lead this witness on a number of undisputed facts. I've checked with my learned friend. He has no objection. So the judge will say, fine, go ahead. And the thing with leading questions is that they are effortless to answer because you're giving the answer. So, you know, the formal stuff like where does the witness work? What is his address? What work does he do? What is his job description? Things like that. You can ask in the form of leading questions. It's not a problem. But when you ask a leading question regarding a disputed fact, you can expect your opponent to object, and the judge will sustain the objection. Now, repeated objections that are sustained discredits you as a lawyer, and it damages your case and makes you look like a fool. Now, one of the types of questions we use is open questions. This type of question assists you to avoid the leading question. Questions beginning with these words, who, what, why, when, where, how, describe, they are not leading questions, but I will deal with this in more detail. Questions beginning with these words are known as open questions. They're not leading and are easily understood by the witness. Then you have closed questions. This is another form of non-leading question. This type is used when you seek a specific answer. You want to confine your witness to giving you a particular answer. What time did you get to work? You want a particular answer. Whose signature is this? You want one answer. You are limiting the witness's choice. But the question is not leading. There must nevertheless be a choice of answer. So when you say, what time did you get to work? The witness has got a choice. It can give any time. But if you ask, what time did you go to get to work? Was it 6:30 or 7? Now you are beginning to cross the line. You see, it depends on how you phrase the question. Voice intonation also plays a part. What time did you get to work? Now that is a closed question, and the witness has a choice of answer. You arrived at work at 7 o'clock. That is a leading question. You are telling the witness what time he arrived at work. What about this question? Did you arrive at work at 6 or 7? Now what? You gave the witness a choice, but you limited the choice to either 6 o'clock or 7 o'clock. Now you're getting dangerously close to leading. Now, what if you asked the same question, but placed a vocal emphasis on 7? So you say, did you arrive at work at 6 or 7? So what does that mean? You're telling the witness, you're giving a choice, or it appears you gave a choice, but your voice emphasizes 7. The witness will say 7. The judge will consider that to be leading. Here's another example. The question is, the man you saw that evening, Was he tall or short or of average height? Here you gave the witness a choice and the judge will wait for a response. This is acceptable. Okay. But you say, was the man you saw tall? That's a leading question because you have given the witness a choice between yes and no. You are close to asking a leading question. It may depend on how you develop the evidence. But what if you inadvertently placed emphasis on the word tall? Was the man you saw tall? Well, you may have crossed the line, and the judge will think you're suggesting the man is tall. This sort of question can be crucial in a case involving identification. All of you, if you prefer to be trial lawyers, you'll come across issues of identification. So the way to avoid this kind of problem is to lay a foundation through the use of open questions. Then use the closed question to bring out specific details. We'll deal with this in more detail in a moment. Firstly, be reminded that you have to carry out witness briefing before the witness is called to the box. A calm witness will hear you better, understand your questions easily, and respond well. Please don't be lazy. Get this done. If you have a competent candidate or a junior partner or a junior counsel, please ask them to do witness briefing with your witnesses, including your client, by the way. You know, we don't have jury trials here, thank heavens. But if you look at what happens in America or in the UK or in Canada, where they use jury trials, they will never, and I mean never, skip witness briefing because juries are a very difficult lot to persuade because these are lay people. And, you know, someone sitting, a member of the jury, looks at the witness and says, I don't like his face. Can't be telling the truth. You know, something as ridiculous as that. They will do briefing to the point where in big cases, they will simulate a courtroom in their offices and put the witness through the whole process. Now, I'm not suggesting you do that here, but witness briefing on the morning of the trial or maybe a day or two before works wonders. Now, there's some things you can do to improve your own performance. Remember, I told you, being a trial lawyer is a performance skill. Now, let's deal with some things that you can do. Firstly, do not write down your questions and have a list of questions from which you lead. That doesn't work. Simply because you end up becoming a slave to that list and you cannot safely anticipate how the witness will perform. So now you start concentrating on your list to see which question you should ask. Bad lawyer. Okay. That's just a distraction. It damages your own performance. What you should do instead is maintain eye contact with your witness, and you will stop and you will maintain eye contact with the judge. So you've got eye contact with the witness when you ask the question, and then when the answer comes out, you're looking at the judge. That list of yours is nothing but a distraction. Don't do it. Good preparation will give you confidence to lead the witness without having to hang on to a list of questions. You see, any performance, whether it is as a trial lawyer or an opera singer or a football player, any performance requires confidence. And confidence only comes from good preparation. Nothing else gives you confidence. You know, you may be one of those that can pull off anything. But if you did not prepare your facts, trust me, the judge will pick it up within 15 minutes of you starting. And from that point on, you're in trouble. Now, yes, let's look at this thing. It's very important. I suggest instead of having lists of questions, have a chronology document that you prepared. You must have two classes of chronology document. One is a chronology document for the trial. That's the chronology document. Firstly, you can hand one up to the judge during opening statement. Then you have chronology documents for each witness. And finally, you have a chronology document to assist you in argument, which you will hand up with your heads of argument. It's a one-pager. Do not hold it in your hands and use it as a crutch. Keep it down there on the desk. Use a large font so you can read it clearly while it's there. Now, just let me go back to this and explain to you why this is so effective. Witnesses don't give you their versions in a sequence. They just tell you a story. It's all over the place. Good lawyer will say to the witness, look, I've got your story. Now, I want to take you through it from start to the end, step by step, in time. So let's go through it again. That's when you write the statement down. It will be in a sequence. You will mark off those facts that are material to your cause of action that you need to prove. When you prepare the chronology document, write down the material facts as you want to present them in a sequence, number it, and you will have it in front of you. You'll have the date or the time. This helps you to do two things. Firstly, it helps with the preparation of the witness. The witness reads the statement and then reads the chronology document that has a summary of all the important facts in a sequence. The second benefit is it helps you to lead the evidence in chief. You've got a chronology document in front of you. The witness is familiar with it, and you will lead from the chronology document. So you've got details of employment as number one. Number two, an incident happened, time. 3, description of the incident. So when you lead a witness in chief, there's a technique which I'll come to where you give the witness a headline. So you tell the witness, what is it that you want to know? So the witness knows what you want, does not get confused, and understands the question. So you'll say, Mr. Jones, I'm going to ask you about your employment. Now you will ask a series of questions to bring that out. When you've done that, you will say, Mr. Jones, an incident took place at 10 o'clock on the morning of the 5th of June. I'm going to ask you about that. Now, that's not leading the witness. Now ask the questions. Mr. Jones, we know that the police arrived on the scene. I'm going to ask you about that. Ask those questions. So what this does for you as a lawyer, it helps you to lead the witness and control the witness, bring out what's relevant. And very importantly, it tells you when to stop. You know, you'll be amazed. Lawyers leading a witness in chief comes to a point where they're not sure if they've done enough. Have they got what they want? And they will ask the judge for a short adjournment to consider their position before they can say that's the evidence in chief. That irritates the judge. The judge goes out, comes back 15 minutes later, and then you say, my lord, that's the evidence in chief. The judge is thinking, but why couldn't you have done that before I left and walked out of court? So what purpose did it serve? It's just bad technique, okay? So this helps you with that. So the best technique, and this will help you to avoid the leading question, always first think of the answer you want. Okay, what is the answer you want? You want the witness to say he witnessed the signing of a deed of suretyship. That's what you want. Now, think of the answers that you want. You want the witness to say he witnessed this document or saw this document being signed. You want the witness to identify the signatures on the last page. So now you know the answer. And now you ask simple, non-leading questions to bring it out. So after you introduced and qualified your witness, now you start leading the witness on the relevant version. Now you can see how important the chronology document is. It's on the table. Make it a habit to lead witnesses in a sequence from start to end, step by step. Judges like it that way. It guides the witness. It helps the witness to settle down and concentrate. Lawyers and witnesses have a habit of taking leaps backwards and forwards into time. We all do it. It's not normal for someone to relate a story in a strict sequence, chronological sequence. It doesn't happen. You will have to show your witness how it works and hand the chronology document to the witness. You do not want to confuse the witness, and worse still, you do not want to confuse the judge. Chronology documents help the judge. When preparing for trial, hand your witness a chronology document. Tell your witness you will lead according to the sequence that appears in the document. Also tell your witness to use the document to refresh their memories, but they obviously must be familiar with their statement. You must also have a list of witnesses in the order in which you want to call them. You will know who your next witness will be, and that witness is waiting outside. Now remember, when you made your opening statement, you told the judge how you intend to run the trial. You told the judge, or you dealt with the issues. Tell the judge who will be your witnesses and what will each one say. So the judge knows that this is coming. And please do this. South Africans are notorious for not turning up in court. Witnesses, there's no guarantee they'll turn up. It may not be their fault. There could be a taxi strike. There could be load shedding there, or there was an accident on the way, and so forth. The excuses are endless. Good lawyer will, the day before, contact the witnesses, tell them that they are expected in court, and arrange the transport. You must make sure that the witness has transport. If they don't have their own transport, arrange it. That way you'll guarantee the witness is there. The number of times cases had to stand by and get postponed because witnesses were not there, I can't tell you. It happens so often. Okay. Also, check if the interpreter is available. These days, you have to book an interpreter. They're not always there. You have to go and hire an interpreter, make sure they are present. If the witness is not English speaking, you cannot move without an interpreter. Check the bundle of documents and exhibits are available and placed in the witness stand for the witness to have access. We're using case lines here. The documents will be on case lines. You must be able to take your witness through the documentation on the monitor. It's also a good habit to have a bundle of hard copy documents with the same pagination as we have on case lines available in court. The documents must be in order: pleadings bundle, minutes of the pre-trial, case management conferences, bundles of discoveries, etc. The idea is for you to be organized. That way you will not irritate the judge. You know, when you're disorganized and you have to keep saying, would your lordship bear with me while you're shuffling around with paper, it doesn't look good at all. Eventually, the whole country will be filing papers electronically. We will not be burdened by many lever arch files as we have. I wrote a chapter on managing documents electronically and on case lines in my book called Trial Advocacy. I'll refer you to that book later. Now, when you, I see it's 2:30. Okay, can we take a 10-minute break before I go on to voice, right? 10 minutes. So we'll be back at 2:45. Okay. Okay, let's start already. I'm just concerned I might run out of time. Okay, I have to, you know, as trial lawyers, one of our main functions is to communicate. We are professional communicators. You have to communicate with the judge. And before you can be persuasive, you have to be heard. You need a strong voice. Now, as a good trial lawyer, you always check the acoustics in your court. Now, if you're appearing in courts all the time, in the same court, you learn to appreciate what the acoustics are like. But if you are appearing in another court where you're not familiar, check it out yourself or ask the local practitioners what it's like. And you need to adjust your voice accordingly. Now, confidence has a lot to do with how you project your voice and how you sound in a courtroom. You know, if you're well prepared, you can make your submissions confidently, you sound good, your quality of your voice is better. You know, as a lawyer, you have to strike a balance between politely audible and being aggressively loud. The aggressively loud is not what you want. Whatever your style or sound may be, you must sound like you are being polite and respectful of the judge and the witness. At the same time, you must be perfectly audible. By the way, we're not all blessed with great voices, you know. But there's a solution for that. If if you're having problems with your voice, or it's not what you would like to have in court, you can cure that problem easily. There are voice clinics that you could go to now. There are voice experts that can fix you up in a week. It doesn't take longer than that. They can give you elocution lessons and they can sort you out. Now, we used to have pupils coming to the Joburg bar who come from places where they picked up strange accents, like people from the Boland in the Cape. They when they spoke, they sort of brayed when they spoke, and they sounded terrible. And we sent them for elocution lessons, and they fixed them up. They were fine after that. So using plain language, everyday language that is easily understood by everyone makes you remarkably audible. That's a fact. If you understand someone, you hear them better, okay? And if you don't understand them, then you have difficulty hearing. It's a human thing. If you must be bombastic, verbose, and difficult to understand, you'll be surprised how many people will have difficulty in hearing you. Just go into a courtroom and see what happens. It's absolutely true. Now, when you speak, it is important to actually direct your voice. Speak in the direction of the person you are addressing. This will be the judge or the witness. Maintain eye contact with the witness. That helps. And also make eye contact with the judge. Have a clear voice, ask short questions, use plain language. That works. And, you know, I told you, what happens in a courtroom is a performance. And like every other performance, it can be boring. Never lead a witness in a boring, disinterested monotone. This is a performance skill. If you look uninterested in your own witness, don't expect the judge to be enthusiastic about it, okay? If you normally speak in a boring monotone, and there are people like that, seek professional help, correct it. When you ask questions, make it sound like something the witness and the judge will be interested in. When the witness answers, pay attention. Hang on to her every word. When your enthusiasm will encourage the witness, and the evidence becomes more persuasive. So while your witness is talking, concentrate on the witness. Don't start writing notes or shuffling your paper or talking to your junior or your assistant. You become a distraction for your witness and for your judge. And it's also important for you to observe the judge. Is the judge following your pace and that of the witness? There are judges who like taking notes. You must pace yourself according to the judge. You know, if you gallop ahead of the judge, they don't like it. You don't want the judge to stop you and remind you to slow down. Not persuasive. You need to strike a workable pace and rhythm between yourself, the witness, and the judge. It's like being a good juggler. But with experience, you'll get it right. It is very important to you to listen to the answers. You will need those details for your argument. Do not rely on the fact that you know the answers and the responses. You cannot have total control of your witness, and sometimes the answers will not be what you were expecting. And trust me, this happens. You know the answer, you've dealt with it in consultation, but the witness will tell you something that will take you by surprise. Okay. Now, let's go back to the types of questions. Let us repeat the rule. One question, one fact. Short question, which must be understood by the witness only in one way. No ambiguous questions, no multifaceted questions. It must sound like you are holding a dialogue or a conversation with your witness. Let's look at some examples. Look at these questions. Where do you live? Where do you work? What is your job description? One question, one answer, not leading. Now look at this question. Well, Mr. Smith, tell the court where you live, where you work, and what is your job description. No good. Okay, don't do that. Don't do that. You see, a witness may be nervous. When you stand up and ask multifaceted questions, the witness might answer only one of the three answers and ignore the other two. It's not fair to your witness, who is under pressure to remember the list that you just fired at the witness. Most witnesses will respond to the one question or two and keep quiet about the next question. And you could easily leave out a piece of important evidence. And by the way, your opponent will see it. And your opponent will say in argument, well, your lordship will remember that Mr. Smith didn't answer that question. Except that your opponent will comment and say, well, Mr. Smith was evading that question. Now, telling the story, while it's a good technique to use short questions to elicit a particular answer, judges generally like to hear the story from the witness. So a series of short questions might not bring out the narrative the judge is looking for. Here, you should do the following. When you get to the disputed facts, in other words, the disputed part of the version, consider the following. This is when the judge leans forward and wants to hear, because now this goes to the heart of the issue and the judge has to come up with an answer. When you get to this point, allow the witness to tell the court what happened. Don't interrupt. Let the story flow. Interrupt only when the witness drifts away or becomes irrelevant. Just bring them back. When you have what you want, sit down. Do it confidently without looking smug. Now, I'll tell you what a good handling of the witness looks like. You lead the witness tells the story. You don't ask for any adjournments. You look at the judge and you say, evidence in chief, my lord, and sit down. It's slick, it's professional, it's persuasive. Now let's go to a method that will help you to avoid the leading question. There's the headline method. I explained it already. It's what we call signposting. It's what you do before you ask your non-leading questions. Tell the witness where you are going. What is it that you want to know? For example, Mr. Jones, I'm going to ask you about your employment. But now, that's not a leading question. Then follows short questions to bring out details. Another example, Mr. Smith, I'm going to ask about an incident which happened in Vilakazi Street. The witness knows what you want. You will then get the witness to explain what happened in that street. Mr. Maseko, I'm going to ask about a document you will find on page 65 of the bundle in front of you. You see, now you've guided the witness to say, this is what I'm going to ask about. Now you are ready to ask questions. So why does this work? It tells the witness what to expect from the witness. It helps you to arrange your examination in separate topics. In other words, your examination in chief will have an order. There'll be logic to it. The judge will be able to follow it. It prepares the witness to answer your questions. It avoids confusion. It helps you to avoid using leading questions, very important. And the judge knows what to expect. We call it giving the witness a headline. Now, here's a practical suggestion. Write those headlines down in your chronology document. It makes it much easier for you to lead the witness and to control the witness. Then we have the next technique, which is coupled with the first technique of giving the headline, and this is called looping back. The looping back method, the looping method, or piggybacking method. So when you use signposting in combination with piggybacking, you will avoid the leading questions. As the name suggests, you ask your next question from the answer to the previous question. Hence, you are piggybacking or looping back onto the previous question. When you do that, you are not going to be leading. There's a quick example here. Mr. Jones, where do you work? I work at Checkers. What work do you do at Checkers? I'm a floor manager. For how long have you worked as a floor manager? 12 years. During your 12 years, 10 years, how often did you take sick leave? I took sick leave only twice. On both those occasions, did you provide a medical certificate? Yes. To whom did you present the medical certificate? To the human resources manager. Who is the HR manager? It is Mr. John Ruiz. Do you see the questions just flow from the answer to the previous question? And it's a very useful way of doing it. So these are simple fact sets that are not likely to be disputed. These are the undisputed facts. Now, you see, undisputed facts, I told you, you can bring it out using a leading question. So look at this. Mr. Smith, I'm going to ask you. Now, here, the witness is dealing with disputed facts. I'm going to ask you about an incident that took place on the 14th of July. There's the headline, okay? Where were you on that date? I was driving my car on Main Street. Where is Main Street? In the CBD of Benoni. Now, if you go to page 17 of your manual, the one that's been sent to you, you will see an example. I don't have the time here to take you through it. You can go through it yourself, but you will notice that the lawyer piggybacked on the answers to previous questions. The evidence was given without the lawyer having to lead without leading questions. And also you'll notice the technique of signposting. Let's go back to the closed question. As I stated, you could easily fall into the trap of asking leading question. The best technique is to lay a foundation for your closed questions by beginning with a series of open questions. Here's an example, going back to the accident case. Mr. Smith, you saw the defendant attempting to get out of his car. Yes. When you observed him getting out of the car, what caught your attention? He was fumbling with the door and struggling to exit the vehicle. When he was struggling to get out of his vehicle, was he injured? No, he was not injured. What was his condition? Was he sober or drunk? He was drunk. Now you see, that last question, Smith gave a choice of sober or drunk. Smith will have to be careful about his voice intonation. He's not to say, was he sober or drunk? That's not going to work. But although he gave only two choices, he set the he set the stage where he can ask, was he drunk or sober? The underlying question, this one, what was the condition? Was he sober or drunk? That's a closed question, but it could be seen as a leading question where the lawyer gave a choice of answers, but the lawyer is obviously looking for a certain response. You will get away with this question because a foundation was laid with the use of open questions. But watch out for your tone. Don't emphasize the word drunk. Now, here's a irritating habit which practitioners have, where the lawyer will repeat the answer that the witness gave. Now, they do this to buy time to work out what do they ask for next. This is a symptom of a disorganized lawyer. If you repeatedly repeat the answer back to the witness will say, I am a floor manager at Checkers. Oh, Mr. Smith, you're a floor manager at Checkers. Well, it's just so irritating. It wastes a lot of time. Besides, it creates the impression that you are overemphasizing a point. Well, it's all very well, but what happens if it's the wrong point? You must avoid random or idle repetition. Now comes another technique. You know, when you lead your witness in chief, you already know what is the material fact that you want to come out of this witness's evidence. It's what we lawyers call the bullet point. The answer may be worth repeating in order to emphasize the fact, but there's a method. When you repeat the answer, you do it in a certain dramatic way. Take an example. Here's the example from an accident. What did you observe about the defendant as he was struggling to exit his car? I noticed that he appeared to be drunk, says the witness. Mr. Smith should go, you look at the witness meaningfully and say, he was drunk. Smith slowly repeats the answer, pauses, lets it sink in, looks at the witness, and then looks at the judge. The witness will say, yes, he was drunk. And as the witness says, yes, he was drunk, Lawyer Smith looks at the judge with a meaningful stare. That's the dramatic part, okay? By the way, being a good trial lawyer requires you to be an actor as well, okay? There is an element of drama in a trial. You can't avoid it, okay? So it works, but reserve it for your main point only. Never overplay it. Once you've got the effect you want, move on smartly. You do not want the judge to think that you're being a drama queen, okay? Or playing to the gallery. That's even worse. Okay? Now, you're communicating with the judge. It's your function in court to persuade the judge to accept your client's version. So let's not forget that throughout your performance, you are communicating with the judge. Now, these are the things that will assist you. We mentioned that you must be audible. The judge must hear you, okay? When you lead your witness, involve the judge. You know, it's so easy for you to become engrossed in a conversation with you struck up with the witness and you momentarily forgot the judge. Bad technique. You must maintain eye contact with the witness, eye contact with the judge, and involve the judge. You know, you want to draw the judge's attention. You know, the subject of the witness's evidence usually is never anything exciting, okay? It's boring stuff, basically. Someone describing an incident they saw. It's boring stuff. But you have to work hard to hold the judge's attention. So what you should do is, instead of saying to the witness, tell the court what happened, a good idea is to say, tell his lordship what you observed about the defendant. Say, I'm certain his lordship is interested in what happened to the defendant when the police arrived. Each time, the lawyer is making eye contact with the witness and the judge. So instead of saying, what did you notice about the witness? Or what happened when the police arrived? Well, if it's important, say, tell his lordship. I'm sure his lordship would like to hear that. Now, pacing yourself is important. Judges, some of them write copious notes, others don't. Those judges just sit and listen, and it's a pleasure, but there are others that will insist on writing everything, and you have to keep pace with them. Observe the judge, see if the judge is interested and listening. You know, rumor has it that judges sometimes stop listening. Now, here's an indication. You know, when the judge interrupts you, it's 10:30, and says to you, Mr. Smith, do you think you will finish with this witness by tea time? What does that mean? Okay. Is the judge so desperate to have tea? No. He's just reminding you that he's bored to death and he would like you to sit down now. You failed in persuading that judge. Always maintain eye contact with the judge, and for God's sake, do not turn around and make eye contact with the gallery. I've seen lawyers do this. They think they've asked a brilliant question and they turn around and look at their fans sitting in the gallery. Judges hate it. Just don't do it, okay? The fans in the gallery don't matter. And never lead your witness. No matter how boring the subject, you must appear to be interested in your witness. It's your witness. It's your client's case. You must be interested in your witness. Well, this is the technique. Do not ask leading questions. We've dealt with that. Think of the answer that you want. Then ask non-leading question to bring out the answer. You will generally know what the answer is. This avoids nasty surprises that come from answers you were not expecting. That definitely undermines your case. But if you prepared your witness well, you will be confident to elicit the details that you want from your witness. When you can ask a question where you do not know the answer, then you can ask a question where you do not know. But be aware of the situation. There are a number of issues not addressed in the witness's statement. Consult with the witness before they take the stand. You must do a witness analysis. There are two things you must do. Your case concept, firstly, your case concept and where the witness fits in, you must know that. Secondly, your witness analysis will tell you what material facts you need from the witness. Now, I'll tell you why this is so important. It is so easy for a lawyer leading his own witness to forget to bring out something. And it could be an important piece of fact. It's in the statement. And then comes that horrible question during cross-examination. Witness, did you tell your attorney? And that is going to cause endless damage. You know, when you ask that question, did you tell your attorney? It's a no-win question for you. Because if the witness says, no, I didn't tell my attorney, then there's a suggestion that this is a recently fabricated version. If the witness says, yes, I told my attorney, well, no one believes this witness because we all know the attorney or the advocate takes instructions from the witness. So if he didn't ask, the witness didn't tell him. So it discredits the witness. Always use your chronology of the witness's evidence when leading. It's easy to follow. The judge absorbs it. Now, setting the scene. This is important. You must remember, the judge is hearing this version for the first time. What does the judge know up to this point? The judge knows what the issue is. The judge has read the pleadings and the pre-trial minutes, and the judge has heard you in your opening statement. The judge is hearing the story for the first time. Set the scene before you get to the details. It helps the judge to understand, as she will have the background and the context. For example, do not ask a witness to describe how an accident took place without setting the scene. It's useless saying to a witness, tell his lordship what you observed. And the witness goes around and saying, well, I was walking down Main Street, and as I was walking down Main Street, another car came up Main Street, and then the defendant's car came from the left-hand side and did not stop at a stop sign. I mean, who knows what this means? The judge has no idea. The judge is confused. Now, how do you do this? Set the scene. Use visual evidence. Before you tell the witness to explain what happened, tell the witness to explain the whole scene. Put a photograph in front of the witness and the judge. Use an aerial photograph. You can get that off Google Maps. Then get the witness to indicate on the photograph where the witness was located, from which directions the vehicles came, etc. Now, when the witness describes how the accident took place, the judge is with you. Okay. So, by the way, using the visual evidence is highly recommended. Okay. Lead the witness in plain language, simple questions. Do not be tempted to use lengthy and unnecessary introductory remarks and preambles, okay, such as, Mr. Jones, will you please elaborate by telling his lordship precisely what color was the car when you saw it enter the intersection? I mean, that's terrible. You could easily have said, Mr. Jones, what was the color of the car? Simple. The judge wants to hear the story from the witness. Allow the narrative to flow, especially where you are dealing with the disputed facts. So what happens where the witness gets stuck or does not know where to go next? Or the witness forgets an important fact? You can deal with that easily. You'll go, Mr. Jones, let me stop you there for a moment. Let me take you back to the intersection after the police arrived. And now ask the questions. The witness will remember. Allow the witness to testify in fact sets. In other words, describing one scene change to another. What you have to do is control the witness and keep it relevant. That's the important bit. I've dealt with chronology. Use your chronology document. I've explained this many times. Get into the habit of preparing chronology documents. By the way, I don't see why you should not make chronology documents part of your routine in preparing for trial, because you will be forced to do so anyway. And you'll have to do it every time you go on appeal. You have to file this chronology table with your heads. You'll have to do the same in the opposed motion court. Do it in a trial. It assists the witness, it assists the judge. Now, paying attention to your own witness sounds very obvious, but I've come across lawyers who don't listen to their witnesses. They get distracted, or they look distracted. They're not concentrating. They're not keeping eye contact. That's very bad. I dealt with pacing. If the judge is struggling to keep pace, say something like, Ms. Naidu, will you please slow down to allow his lordship to make notes? Simple, okay? Now, so you can help your witness to make the story interesting and to hold the judge's attention. This is where your communication skills come in. When the witness makes a material conclusion, don't let it slip by. That's your bullet point. When the witness says the defendant was drunk, the lawyer allows a short pause to let it sink in. Officer, what did you conclude from the defendant's behavior? Now you look at the judge, and the witness says he was drunk, my lord. So this is a useful technique. There's some drama in it, but it works. Now, witness analysis is important. Tells you what each witness will say and where it fits in. You have to make certain that you get a complete set of facts from the witness. Now remember, if you're plaintiff, you will have to discharge the onus. The onus will be on you. So you cannot afford to fail to prove a material fact which is part of your cause of action. Then you will fail to discharge the onus. Likewise, a defendant will fail in the defense if they do not provide proof of certain material facts. It's so easy to miss this out. Remember, your witnesses will not know this. They are not the lawyers. You will know it. Now, when you're ending the evidence, a well-organized lawyer knows when to stop. I've dealt with this. Please don't ask for an adjournment and work out whether you've covered everything or not. It just wastes time. And here's some bad habits. Do not respond to your witness's answers with a comment or an opinion. For example, you get a question, you get an answer, you keep saying yes after an answer. You ask a question, you get an answer, you go yes. And then another question, you get an answer, you go yes. Don't do that. It's not important. You don't have to do that. Repeatedly saying, yes, I see. It's just a bad habit. Okay, now let's deal with cross-examination. This is a fundamental part of the adversarial system. Remember, the two parties are opponents. They're adversaries. That's why we call it the adversarial system. Although the lawyers, I keep saying, should not be the adversaries, but there are two conflicting versions. The judge needs to decide which one to accept. Cross-examination is very helpful. It helps the judge to establish what actually happened. and is essential for the purposes of resolving disputes of fact. Good cross-examination comes from good preparation. There is no shortcut. You probably worked out now, litigation is not for lazy lawyers. Just forget it if you're lazy. It won't work. Before I go any further, you cannot possibly cross-examine effectively if you did not prepare well. That preparation involves you carrying out a fact analysis before you come to court. What is a fact analysis? Quite simply, you have to go through all of your evidence, write down what are the facts that support your client's version of what happened. Those are what we call your good facts. Now you need to write down what are the facts that do not support your client's version. Those are the bad facts. When you cross-examine, you want to bring out the good facts and you want to discredit the bad facts. You can't cross-examine meaningfully if you do not know, haven't done a fact analysis before coming to court. In fact, I say it is downright negligent if you do not do a fact analysis before coming to court. Nothing prepares you better for cross-examination. So let's deal with this question of credibility. It's one of the things judges look for in cross-examination. So it's well known that one of the purposes of cross-examination is to damage credibility of your opponent's witnesses. Judges dealing with disputes of fact rely on cross-examination to assist them with the question of credibility. Now, you see, credibility is important because when a judge evaluates the evidence, the judge is evaluating the performance of the witness. If the witness lacks credibility or the credibility is destroyed, the judge doesn't have to take it any further, rejects the evidence right there. The judge doesn't have to test the probabilities, does not have to test whether this amounts to a material fact in the cause of action, none of those things. Out it goes. The witness's performance under cross-examination is vital to a judge. As a practitioner, it is useful to know how judges set about an analysis of the witness's credibility. There are a number of factors. A judge asks the following questions. It's always good to know how judges work, because then you can craft your approach accordingly. Is the witness a truthful or untruthful witness? Untruthful person? Is he, though a truthful person, telling less than the truth on this issue? Is he, though an untruthful person, telling the truth on this issue? Is he telling the truth as he sees it? That is, has his memory registered events correctly and reliably? Is his memory subsequently influenced by unconscious bias or wishful thinking or by conversations with others? So you see, these are things that go through a judge's mind when they are testing credibility. Has his memory become fainter or more imaginative with the passage of time? What is the probability that he was mistaken? Well, you could have made a mistake. There's this famous South African saying, an honest mistake, okay? Is this evidence motivated by hope of gain, the desire to avert blame or criticism, or misplaced loyalty to one or other of the parties? Is the witness's evidence consistent with what is agreed or clearly showed by other evidence? That includes the undisputed facts. Is the evidence self-contradictory or otherwise inconsistent with a previous statement of the same witness? So do you see, there's a whole list of, given you a list of about 10 things which judges are looking for. When you're preparing cross-examination, look at those questions. They will assist you in formulating your plan when you cross-examine a witness. So the first thing the judge will do is look at the basics. Firstly, the source of what the witness tells the court. Where did the witness get it from? Judges prefer to hear evidence from witnesses who have personal knowledge. That's the eyewitness. The circumstances which gave rise to the witness becoming involved. Judges are interested in that. How did this person become a witness? Was the person there? Did someone find him? How did he end up in court? Judges need to know that. Also, if you are cross-examining your opponent's witness, ask these questions, but always remember, you must know the answer first. How, when, and under what circumstances the information came to be retained? Can the witness produce a contemporaneous document as support? Now, you know, it's not fair, and it's not a good justice system where trials can take between 3 to 6 years to get to court. The culprits are mostly the lawyers, of course, but these delays are becoming ridiculous. And now with the load shedding playing havoc with our court rolls, we're not compressing the time. So the witness will come to court maybe 3 years after or 4 years after the incident took place. So typically, the following questions may arise in the mind of a judge. Does the evidence involve something that happened very quickly? Did the witness have enough time to make a reliable observation and to recount it in court? Judges are concerned about that. This is something you will deal with in cross-examination. Has the witness been exposed post the event to misinformation concerning the event? You know, do not underestimate the influence of social media networks. Be alive to this. Check out what the witness was exposed to. If there's something about this incident in social media, there have been comments, there may have been something in the newspaper and so on. This may distort his recollection of what actually happened. Currently, I say the most distorting factor is exposure to social media networks. You'll have to start contending with artificial intelligence now, because now it seems that with artificial intelligence, you can just about simulate anything. You could simulate an accident and put it on the network. It looked like somebody caused it. You can simulate voice. You can simulate people's voices. I mean, it's just quite ridiculous. Has there been loss of recollection over the passage of time? We all know how memory can fade, but it can even fade selectively. That's what judges are looking for. Is the witness's recollection supported by contemporaneous notes? If so, were the notes made independently or in conjunction with another person? Independent contemporaneous notes will support the witness. If that happened, use it. Unfortunately, witnesses don't do this unless there was some reason to make a note. Bias is very important. That can distort the witness's recollection. Look for bias. Now, what I've done here, when it comes to physical conditions, in cases involving issues such as identification, the negligent cause of a collision, or some kind of event that the witness has to talk about, these are the things that the judge will be concerned. And if you're cross-examining, this is what you are going to do. What about the lighting? Was it dark? Had the sun set? Was there artificial light somewhere? What was the lighting? Distance. How far was the witness from the incident that he was observing? The further away the witness, the less reliable the observation will be. What were the weather conditions? Was it raining? Weather can cause an interruption of one's sight or vision. Knowledge, this is important. Does the witness actually know the person she's identifying? Now, there's a big difference between recognition and identification. Where the witness is relying on recognition, the witness says, I know this person, it's my neighbor's son. That's solid. Judges like it, no problem. Identification is different. This is a stranger. The witness is now saying, I know it, I've identified the driver as being the defendant. So knowledge is important. The witness's knowledge of the intersection. I drive through it every day. I know that the robots were not working for 3 months. Very convincing, okay? Obstructions. Did the witness have a clear view? These are the things, these are the points, these lists that you will go through. Bear that in mind. There's some cases, I've given it to you there. It will help you to handle witnesses more effectively. Now you know what to do when you want to discredit or undermine your opponent's witness's reliability. So you've got these tests that you can use it in cross-examination. But again, the warning, never ask a question if you don't know the answer. Here's a useful case, Stellenbosch Farmers Winery versus Mattel. Go and read that. And now we come to a matter of demeanor. The witness is appearing in court, standing in the witness box, testifying. So what is this demeanor about? Well, just let me say this first. The demeanor is what the judge sees and hears in court, sees the witness, observes how they testify, observes them under while being led and then cross-examined and so on. As a matter of this is something lawyers need to know. Judges would broadly fall into one of two categories. There are those judges who think demeanor is a very good indicator or marker for credibility, and they take demeanor seriously. In other words, they carefully observe the performance of the witness in the witness box. They'll make notes about it. They'll say something about it in judgment. Then there's the other school of thought, that demeanor is not a reliable indicator. Why? Because a witness's demeanor may be poor, not because they are lying or deceiving the court or being dishonest, but because they're just nervous. And that's true. A witness's demeanor can look terrible because they're just nervous. That is why I insist you should use witness briefing before you call your witness to court. Now, my advice to you is don't take a chance. Don't speculate whether this judge will take demeanor seriously or not. The judge gives an indication. Those judges who observe and write notes about what they see in the witness box, you know they're taking demeanor seriously. Other judges don't give you an indication. And in fact, they don't even say it in their judgments, but they were influenced by the demeanor of the witness. So what I'm saying to you is, don't take chances. Firstly, prepare your witness so that the witness's demeanor does not unnecessarily suffer. By the way, you will not eliminate nervousness through witness briefing. It's not possible. But you can manage it. The witness will be less anxious. They'll be less nervous. The demeanor would be better. Okay? So what are judges looking for? the expression and bearing in court, the voice, clarity, confidence, the tone, and then there's this thing called voice fade. This is when the voice tends to become progressively inaudible and the judge has to repeatedly tell the witness to speak up. There's something that you need to notice. When someone starts lying in court, the voice also starts fading, and then someone has to remind them, can you speak up, please? Eye contact with the judge and the lawyers. Confident witness is maintaining eye contact with the lawyers and with the judge. Response to questions. Is the response spontaneous or is it evasive? Does the witness not answer the question? Does the witness keep asking for the question to be repeated? Okay. Answers the substance of the question. Does not buy time by answering with asking another question. This is an old trick of an evasive witness. Hesitancy, feigning lack of understanding to simple questions, taking too long to answer, asking for question to be repeated, is being suspicious, is cagey and unapologetic. Those are the things that assist the judge with making an assessment of demeanor. One of the reasons why appeal judges are reluctant to upset a trial judge on findings of fact is because of the trial judge's advantage in observing witnesses, hearing them, seeing them. Okay. So when you cross-examine, there's a technique you can use where you remember when a matter goes on appeal, the demeanor is not on the record. The record doesn't have anything about it. Only the judge sees, and if the judge says something in the judgment, that will be on record. But there's something you can do to discredit your opponent's witness. Let's assume the witness is now warned by the judge to speak up. Now, the judge will say, could you speak up, please? That's on record. The witness has suffered voice fade or is inaudible. You come in and say, Mr. Witness, you repeatedly drop your voice. Even I'm having difficulty in hearing you. Could you please speak up? You've got this all on record now. Okay. Witness, I see you keep looking at your shoes. You looking down at your feet. You never once looked in the direction of his lordship. You've got it on record, okay? But, don't overplay it. Now, here's a checklist to prepare you for cross-examination. Everything involves sound preparation. You can't cross-examine if you don't know all the known facts of your case. You must know the triable issues. You must know who bears the onus. You must have done a proof analysis. Have a firm hold on your case concept. What does your client want from the litigation? What happened according to your client's case? You must do a fact analysis as I explained it. Make a list of the undisputed facts. This supports your client's version and it is very effective in cross-examination. Make a list of facts that do not support your client's version, but support your opponent's version. Now that's going to come out in your opponent's evidence in chief. You will want to undermine that. Carry out a witness analysis, identify all your witnesses and arrange them in order. We've dealt with that. Witness briefing, bundling of documents, audiovisual evidence must be in court and available. You must have all the requirements. Let's say you want to show a video in court. You must have a laptop, you must have monitors, and so on. Remember, our courts have nothing, okay? Now you don't even have electricity. So you have to provide everything. you must write heads at an early stage before you come to court. Check the interpreter is there. Now, the fact analysis. To be effective at cross-examination, you must do an analysis. This is what analysis helps you with. Which witnesses to call, which not to call. What facts to bring out from each witness. What you require from your opponent's witness. What questions not to ask your opponent's witness. And you must know when to stop. Now, here's some suggestions. For each witness, prepare a structure. Make a note of the facts you want and bring them out in a sequence. Now remember, if you wrote this as you read, as you prepared, as you researched, and made your notes as you went along, you will have these things. Or if you don't have it in the form that you want it, you can fix it quickly from your draft. Your first note will become your first draft. Writing as you read and writing as you research will make you very efficient. You will take less time, okay? Remember, one of the lifeblood of the legal profession is this thing called billable hours. You cannot spend more billable hours than what your client will pay for. You need to be efficient. Writing as you read and writing as you research will make you more efficient. You want to deal with a specific fact set. Complete your questioning and move to the next. That's your plan. Now, remember I told you, write a headline. There's a fact set there. You want to bring that out, then move to the next fact set. The structure will be in your chronology document. You see how useful this chronology document is. For each witness, map out the purpose of your cross-examination. In point form, set out what you need to deal with and the order in which you will deal with it. You don't cross-examine just for the sake of doing so. You must have a reason to cross-examine. There must be some facts that you want to get out of your opponent's witness. And by the way, if there's no reason to cross-examine, don't. A better technique is to say to the judge, well, my lord, if that's the evidence in chief, I have no questions. Sit down. That's better than standing up and asking some useless questions, wasting the judge's time and then sitting down. Now, cross-examination is about persuasion, creating the impression in the judge's mind. It's a performance skill. If you are going to stand and read out of a list of questions, you look wooden, there's no expression, you are stuck in this piece of paper, you look really bad, the judge gets bored with you. And also, if you're stuck with a piece of paper in front of you, you will lose eye contact with the judge and with the witness. What you should do is just write the points that you want from this witness. Okay. And then frame the question while you're on your feet. Now, I'll tell you what the trick is here. The points that you write is the answer that you want. You've got the witness's name. What are the answers you want from this witness? And you can start writing that by making notes while the witness is testifying in chief. Now you can frame the questions while you're on your feet. Why? Because it's done already. You've got the answer. The witness was drunk. That's what you want to know. So you tell the leading question. You saw the witness. You saw he stumbled. He was unable to open the car. He was fumbling. He was drunk. You see, that's how you're going to deal with it. Okay, so your bullet points will look like this. There's an example. The time is 8 o'clock. Okay, that says something about the lighting. So now you formulate your question. Mr. Jones, the sun had set. It was, yes. It was dark already. Yes. It was approximately 8 p.m. Yes. You see, you've got it, dark. Mr. Jones, there was no lighting in the area. The lights were not working. You were 100 meters away from the scene. Many people were on the scene. Everything happened so quickly. So you see, you leading questions, put the answer in the witness's mouth, okay? So you put leading questions. It was 8 p.m. Yes, don't ask, what was the time? You put the answer in the witness's mouth. There was no lighting in the area. No. You were standing 100 meters away. Yes. So that's the technique. Now, let's quickly deal with the purposes of cross-examination. You want to elicit facts favorable to your case. That's the main reason. You want to advance your case. You want to challenge the truth and accuracy of the witness's version. Remember, the judge will evaluate the evidence. Judges are expected before judgment to evaluate all of the evidence, not piecemeal. So you want to challenge the witness's version to undermine the witness in the eyes of the judge. You want to discredit the witness. You want to introduce your client's case or give the witness an opportunity to comment. Now, this is not fatal if you don't do it in a civil case. In other words, you don't have to put your client's version to the witness. The witness would have heard it already if they were in court, or your opponent has heard it and the judge has heard it. In a criminal case, of course, it's fatal. To undermine the witness who is still to testify. Now, that's a technique you can use. You know that your opponent has 2 more witnesses outside. You can say to the witness testifying, Mr. Jones, I see Mr. Smith is outside. Yes. Mr. Smith was also there. Yes. Mr. Smith's version is the following. So now you are busy undermining Smith while Jones is testifying. So this is a technique you can also use. If you're effective, you'll find that your opponent might decide not to call Jones, or Smith rather. And cross-examination is also good for parading your own case, to let the judge know now that actually your client's version is the better one. The purpose of cross-examination is not to break the witness. This nonsense of wanting the witness to be carried out of court on a stretcher and so on, that only happens in the movies, okay? Usually that never happens. Sometimes you're lucky the witness is terrible and ends up bursting into tears or something. Well, very rarely happens, but it can happen. And usually it happens because the witness is completely emotional and it has nothing to do with your brilliant cross-examination. Now, one of the questions you have to deal with for the purposes of your case, and that is, if it is not necessary to cross-examine, do not cross-examine. If this witness does not undermine any of your material facts, if this witness does not undermine the credibility of your witnesses, there's no need to cross-examine. If the witness does not damage your case and cannot give evidence that assists your case, do not cross-examine. Ask yourself whether you have any effective ammunition to use during cross-examination. Now, you see, that's the trick. If you don't have any ammunition, leave well alone. You will do more damage, and you might even find the witness gets stronger. You see, that's the whole idea of planning your cross-examination. There are some witnesses that are good. They damage your client's case. but you know that if you cross-examine, it's going to get worse. Better not to cross-examine. If you do cross-examine, keep your questions relevant and keep it short. The rule, or the first rule regarding method is ask only leading questions. If you don't know the answer to a question, don't ask. When you cross-examine a witness, you do not ask, you tell. You tell the witness what happened. You don't ask the witness what happened. A leading question is a question that suggests an answer. A type of question that prompts a respondent towards providing an already determined answer. That's the definition. You can read it. So why do you cross-examine? It's an important tool. It is part of the adversarial hearing. This is where you have to persuade the judge to accept your client's version, not your opponent's. So how do you do this? You have to first think of the answer. What is the answer I want? It was dark at the time. That's the answer I'm looking for. Now ask a series of leading questions to bring that answer out. When you use short leading questions, one fact at a time, you now control the witness. Once you use an open question, it is impossible to know what the witness will say. Don't ask the what, where, how, when question during cross-examination. And the worst thing you're going to do in cross-examination, and don't do it, is ask the witness to comment or ask the witness to explain. Never ask a witness under cross-examination to explain. You will lose control. And besides, if you say to the witness, explain that, do you know the answer? Of course not. If you don't know the answer, don't ask. The leading question controls the answer. Why? Because you gave the answer. You told the witness the answer. Ideally, you should be looking for a single word response from the witness. Yes, no. And that's what you get from leading questions. Now, there's an example there. You can go through it. I'm not going to take you through this thing. You can read it. The technique is to think of the answer you want, then put the leading question, okay? You tell the witness what happened. Now, there's a problem that cross-examiners create for themselves, and it's only human. It is a mistake that happens all the time. I'm going to explain this to you because it's important. Let's say you want the witness to say that the driving conditions were dangerous at the time. You want the witness is saying that your client caused the collision. Your instructions are, your version is that the driving conditions were so bad, and that caused your client's car to skid or whatever and cause the collision. Okay. Now, the answer that you want is that the conditions were treacherous. Now, the witness gave evidence in chief. We explained how your client was driving negligently. Now think about it. Do you think this witness is going to tell you that, yes, the driving conditions were treacherous? They're not. That's against the evidence. What you do is the following. You will say, Mr. Jones, you were driving along Main Street. Yes. It was at about 6 o'clock in the evening. Yes. It was beginning to get dark. Yes. Visibility was poor. Yes. It was raining at the time. Yes. The road was wet. Yes. There was some mist about. Yes. The mist did not help the visibility. yes. Now, good cross-examiner stops right there. Why? Because now you've got all the facts that will enable you to argue that the conditions were treacherous. Bad cross-examiner will do this, will ask the next question. So, Mr. Jones, the driving conditions were bad at the time. Do you know the answer to that question? Do you know what Mr. Jones is going to say? He will say, well, yes, it was raining and the roads were wet, but it was fine. You could drive. So you've damaged your whole cross-examination. You see, when the cross-examination goes well, there's a temptation on your part to ask that one extra question, which will seal it for you. Well, that last question which seals it for you is something you reserve for argument. That's your job. You don't ask the witness to express any views about the driving conditions because he will express a view that's against you. Please remember that. So I've dealt with this in a question, in an example. If you go to page 34 of your manuals, you'll find it there. Just make a note of that number, 34. It's in there. You will see how this is done. The lawyer did not do this. Mr. Wilson, it was raining. Yes. The road was wet. Yes. The driving conditions were dangerous. Wrong question. Because Mr. Wilson is not going to say, oh, sorry. Oh, yes, it was dangerous. You got me. It was really dangerous. That explains the accident. No one does that. Okay. Your job is to argue now. Don't ask that question. You argue. You present argument. The lawyer did not know the answer to that question. The witness could have said, yes, it was wet, but the road was safe to drive on. That's not the answer that you want. It damaged your whole cross-examination. So then it's this question, the extra question. Don't ask. And by the way, here's an example. By the way, when you write heads of argument, your job is to comment about the witness. You must comment. You must say that the witness was lying. This witness is unreliable. It was too dark to see. That's the comment you make. You don't expect to get that answer from the witness. So merely get the facts out, reserve your comment for the argument, okay? So look at the lawyer, look at this. It was 6 in the afternoon. Yes, it was getting dark. Yes, it was becoming misty. Yes, visibility was poor. You see, now that's that extra question. You have to stop with, it was becoming misty. Yes. Visibility was poor is the conclusion you want. That's going to be your comment. Don't expect the witness to agree with you. The witness could say, no, not so bad. I could still see clearly. You just undid your whole cross-examination. Be warned. The best of lawyers can be tempted to ask that one more question. Now, you'll be alive to that if you did a proper preparation, if you knew what you wanted from this witness. You want the facts from this witness that will enable you to argue that driving conditions were terrible. Do not be tempted to ask that extra question. You reserve the conclusions and assumptions for argument. You will then be able to say, my lord, it was Mr. Wilson's evidence that it was a rainy day. The roads were wet. Visibility was poor. The driving conditions were treacherous, my lord. Now, if you asked Mr. Wilson, the driving conditions were terrible, you would have said no, they were fine. Oh, it was wet, but you could drive safely. You can't make this argument. The judge will say to you, but hold on, that's not Mr. Wilson's evidence. He said it was wet, but he also said the driving conditions were fine. You've messed up the whole thing, okay? One of the things you will deal with, and I'm going to go through this quickly, is because it's mostly in criminal cases. It's this issue of identification. If you look at page 37, make a note, 37 of your notes, the manual that you got, you'll see it there. Now, you will see that there's a structure that was used. It is about a witness who identified your client on the scene. You'll see how this is done. The knowledge of the client by Ndaba, the witness, distance, positioning, lighting, observation, clothing, what was the person doing, and so on. If you go to page 38, you will see a complete example of this, okay? Now, let's analyze what you want to get out of these techniques. If you use the leading question, if you only ask questions, the answer to which you know, the lawyer will be in control of the witness and the answers, because only leading questions were asked. The lawyer maintained control because he used the technique of one question, one fact, no multi-faceted questions. Never ask multifaceted questions in cross-examination. Firstly, I think it's unfair to the witness. A judge might get the impression you're trying to confuse the witness, and it discredits your cross-examination. The witness must say yes or no. That's it. And there's a structure to the questions. There's no leaping about. Now, a lawyer will take each fact set and, according to a planned structure, logically build up the questions without giving the witness too much wriggle room. The witness was not asked to describe anything. The witness was told what he saw. That's the way to do it. No conclusions, no arguments, just tell the witness what the witness saw. The material facts were brought out that support your client's version. The questions are asked in a polite manner. Never use sarcasm or insults or gratuitous attacks. Now, before I go on to the next point, there's something that practitioners do. I see it in court all the time. Under cross-examination, they get the witness to repeat the evidence in chief. So they'll ask a question like, Mr. Jones, you said you were driving on Main Street in Benoni. Yes. Tell the court what happened. I mean, for God's sake, how are you helping your case? You're not. You are getting this witness to repeat the evidence. The judge sees, oh, well, the story is consistent, so now you made the witness even stronger. That's not your job. Some lawyers think that they use this technique, which is absolutely rubbish technique. They think they'll get the witness to repeat the version and then see if there are any differences from the evidence in chief, and then cross-examine them on that and say, oh, well, now you've changed your version. It doesn't work because witnesses seldom deviate from the evidence in chief. Oh, there may be some small differences in detail. The judge will say, but hold on, that's not a material difference. You're making too much of this. Do you have any other questions? That's what the judge will do. Well, don't do that. Never ask witnesses to repeat the evidence in chief. Judges get bored with it, and it serves no purpose, absolutely no purpose. There's another example here of a mistake. What I've done is that I've given you these sample examples. You should read it. So look at this one. This is the witness who is observing what happened at an incident. You, Mr. Ndaba, you do not know my client. Yes. You never met him. No. Before this incident, you did not know my client. No. According to you, you saw him for the first time the evening of the incident. Yes. Then, Mr. Ndaba, you cannot say that you saw my client. You could be mistaken. Do you see? The wrong question. This is a matter you will present in your argument. Do not get the witness to agree with you. Firstly, you don't know the answer. The witness could say, no, I know it's him. I saw him clearly. You will never recover from the damage. Secondly, your job is to obtain the facts that advances your case, not affirm your opponent's case, okay? All right. So I've also dealt with previous inconsistent statements. It's on page 43. You can read it. We have run out of time. I see it's just gone 4 o'clock. The system won't allow us to go much further. I want to use this time to answer your questions. If you are keen on trial technique, becoming a trial lawyer, I recommend you get this book. It's called Trial Advocacy, The Art of Persuasion. I will ask Betty to send you order forms, get it. Then I'm going to recommend a book, which I read this book and I thought this is a book that's essential for lawyers. And I'm going to ask you to get it and read it. It's called Think Again by Adam Grant. Think Again by Adam Grant. It's available at Exclusives. I've seen it there. It's quite a new release. You won't regret it. It's a brilliant book. Okay. It's about thinking. It's about reasoning. It's what lawyers do. Okay. Betty, are there questions?
I sent you one, sir.
By the way, Ashraf has already sent me a question, asked a question that, are there any reported cases where the lawyers, where they went to court with a useless case and the lawyers were asked to pay the costs? Mr. Issop, I can't think of a judgment offhand, but I do know that a case in Pretoria where the judge, I think it was Judge Tuchten, who actually said to the advocate, listen, this case has no merit. Why are you in court? And the answer was, well, those were my instructions, my lord. The judge's response was, are you not an officer of the court? And the idea that when you come to court with a hopeless case amounts to an abuse of process is taking hold. Now, in England, post the Wolf Commission on Civil Procedure, the Wolf report actually got case management going. It's been followed around the world where the adversarial system is used. In England, they are punishing the lawyers for coming to court with non-meritorious cases. There's a section in this book on trial advocacy which refers to some authority on it. It is dealt with in the section on ethics. It's dealt with under ethics. You can read it there. But the judgment, but the article, you can Google it. It's called The Pursuit of the Non-Meritorious Case. It's by I forget the judge's name. He's in the SCA currently. He's from the Western Cape. Sorry, there were some other questions coming up, Betty. I can't keep up with it on the screen here.
No, I just sent it through to you, sir.
Oh, okay. I'm just waiting for it to come through. Oh, by the way, I also presented a webinar. If you're interested in this for LexisNexis, which deals with the non-meritorious case. We actually got away with this nonsense for years, but I can tell you, in England, they are punishing the lawyers for doing so. Okay, Beth has asked, can one request further particulars, or sorry, request further documents in terms of 3512 if the High Court rules where you, oh yes, here it is, it's Owen Rogers. Thank you. The judge is Owen Rogers. You can get go and read that article. Can one request further documents in terms of 3512 of the High Court rules where you have already received documents through a Rule 3512 request? Oh yeah, one can always request further documents. The whole process of discovery requires transparency. If your opponent omitted to send you a document or you discovered there is a document, you can always request it. And by the way, we no longer practice this kind of discovery where you discover everything and anything that's in your court file, in your office file. It must be narrow discovery. As long as the document that you seek is relevant to an issue in the trial, you will be permitted to request it and you will get a copy. That's the test. It must be relevant. If the document is irrelevant, don't bother to ask. Okay, Gary asks, what if the witness in cross-examination preempts your argument in closing by saying, yes, it was dark and rainy, but I could see fine? The implication being that so should your client. Yeah, that's exactly the point. But the preemption happens when you use the wrong technique. What you do is you use the technique of asking one leading question after another, okay? So it was 8 o'clock. It was winter, yes. The sun had long set, yes. It was already dark at the time. You don't need more than that, okay? If the witness then adds, but I could see fine, you already moved off to the next question, okay? Witnesses will do that. They're not preempting you. They've seen where you're going with this. And they'll say, yeah, but I could still see. That's okay. Don't challenge that. Just carry on. Because then you will argue on the witness's own version, he could not have seen. Although he did add that he could see, it is not reliable. On the witness's version, his observation was not reliable. The light was fading. Do you see the technique? So stick to the basic techniques. You will do very well. Now, the point I want to make here in closing is that it's all very well to attend a course like this and learn technique. But it's useless if you don't practice the art. Trial advocacy is an art. It's a science. There are methods. There's reasoning. There's logic. If you don't apply yourselves, you don't apply your mind, you are not going to succeed. Now, Rendani is saying, what